Hey, welcome to my channel, or for those of you who do not know, I am Boss Attorney Bri. If you are new to my channel, welcome. Go ahead and hit the subscribe button if you are interested in all the legal tea that happens between celebrities and learning a little bit about business. If you are already a subscriber, welcome back. Thank you for joining me today. As you can tell by the title of this live, we are going to be talking about a lawsuit that was recently done with Rolex and potentially that they won for trademark infringement for people basically creating bust down Rolex or blinged out Rolex or altering Rolexes. So we're going to get right into that today. If you have been to my channel before, you will see my background is a little bit different. My boyfriend set it up for me for Valentine's Day while I was out of town with my mother on her birthday vacation. So I'm still working on like the lighting and the setup and all of that stuff. So if I am stumbling a little bit, please bear with me and grow with me as this channel grows. So let's just get right into it. We're going to be doing something a little bit different today. If you've joined me before, I usually go through lawsuit complaints, but today I am actually going to be going through a court opinion. So this case went all the way to the end, and the court made its decision on whether this company has been infringing on Rolex's trademark for Rolex and various other trademarks that we're going to talk about within this lawsuit. This case just ended on January 31st, 2022. And technically, I guess it's not all the way ended, but they are wrapping up, I think, by February 19th is like the last day that they have to submit some paperwork before they fully close out the case. So this is still a fresh case. They're not all the way completely done. So let's get right into it. And let's see here. I have some stuff I wanted to look over. All right, so let's pop on to sharing my screen here. Oh, what is it doing? I'm already struggling today, so. It's not giving me the option. Let me see what it does. Okay. Oh, I forgot. I've been gone for a week. I forgot how to work this thing. All right. So we are just going to jump right over into sharing the lawsuit. There we go. All right. So before we get started into this lawsuit, I do want to ask you guys, do you think that you are trademark infringing when you, one second, would you consider it trademark infringing when you bling out your Rolex watch? So let's say you bought a Rolex watch and then you take it to a jeweler and get diamonds and all kinds of extra stuff put onto it. Do you think that it has more value or less value? And basically, that is what this case is about. That is what the court is addressing. So this case is from Rolex Watch USA. If you don't know what a Rolex is, it's basically a luxury watch. They've been around for many years and they are very, very expensive. And they tend to hold their value because Rolex gives this warranty of that it's going to work for a long time. And if it doesn't work, then they'll fix it within a certain amount of time, which we are going to go over in this complaint as well. So Rolexes, if you don't know what it is, I will show you what it is a little later on. And it's just it's a fancy watch. Mostly men wear it, but they do have women watches. So this is by the company Rolex versus Becker Time LLC and Matthew Baker. This was a district court, a federal case because it's for trademark infringement, and trademark is generally federal law. There are state laws involving trademarks, but this case is brought into a federal district court. And you see all the case number and all of that good stuff there. And so I was able to get the complaint a little bit bigger so you guys can see it a little bit more clear. If you are in the chat, go ahead and let me know where you're from. If you're watching this on the replay, go ahead and drop in the comments where you're from. And if you are interested in Rolexes, or you have a watch, or you have a Rolex watch, go ahead and let me know, okay? All right, so we're just gonna go through the opinion. Remember, this is not a complaint. The judge has already decided this case, and that's what we're looking at today. So the court says this is a trademark infringement dispute brought under the Lanham Act and involves allegations of counterfeit and infringing use of Rolex's trademarks. Becker Times sales of refurbished luxury watches. So it basically means that they're just kind of redoing the watch their own way and selling it to people. If you're familiar with Rolex watches, they don't, I think they're coming out with more with like factory set diamonds in the watch. But when you see like those bust down rollies that rappers have, it tends to be more along the lines of someone else messed with that watch. And I'm going to kind of spoil the incident, is that it lowers the value. So if you think that it lowers the value, or you think it should increase the value, please feel free to comment in the chat and let me know. And then we can go over it a little bit later. And so I'm just gonna go through some comments real quick. We have I Like to Fish from Tampa. Well, welcome from Tampa. I'm happy that you're joining me here on live today. Let me know what you think about this case. And then we also have Snuggles. Do you know watchmakers, and do they have any YouTubers that are watchmakers? I don't know any watchmakers, but I'm sure if you search on YouTube, you can probably find a lot of watchmakers or people altering watches. But as you can see, or we're going to get into in this case, altering watches may not be the best course of action to take. So let's pop back into everything here. And all right, so they're doing refurbished luxury watches, and they don't just do Rolexes, they do other watches as well, but Rolex is the one that brought this lawsuit. And then Becker Time has been in the watch business since 1998, so they've been doing this for a long time. What is that, 24 years? I think that's 24 years, the year my sister was born. So yeah, 24 years. Oh, and her birthday is tomorrow. But anyways, Becker Time describes itself as specializing in buying, selling, and trading pre-owned luxury timepieces, which of course Rolex will fall into because those are the type of watches that they make. Becker Time's business consists of reselling vintage Rolex watches, making repairs to Rolex watches, and selling refurbished Rolex watches. The parties disagree on whether these watches are Rolex watches or altered watches for the purpose of this lawsuit. So basically what is happening here is that Becker Time decided they're going to start messing with Rolex watches and turning them into something else. And we're going to look at their website in a minute, and we're going to see how involved they were with messing with Rolex watches. It kind of, to me, looks like it's their bestseller, so I can see why they wound up in this lawsuit. In September 2020, Rolex and Becker Time, in September 2020, Rolex sued Becker Time alleging counterfeit and infringing use of Rolex's trademarks in connection with advertising, promotion, service, and sale of watches, watch parts that are not authorized or sponsored by Rolex and that are not genuine products of Rolex. Rolex seeks to enjoin Becker Time from infringing its trademarks and to force it to disgorge any profits relating to infringement. The parties have waived their jury trial. So basically, what all of that means is that they want Becker Time to stop doing what they're doing. They want them to stop basically altering the Rolex watches, which is the enjoining. And then they also want Becker Time to pay them all the money that they have made from making these alterations to Rolex watches. And that can be a lot of money, because just using the Rolex name will give them the right to charge a lot of money. Rolexes, start at $4,000, $5,000. So we can only imagine what they're charging, and we're actually going to get into it a little later on. So let me know if you guys have heard of this case. And if you know anyone that has like an altered Rolex watch or wants a bust down Roly, and I keep saying that because that's what the rappers call it. So these are just the facts that the court found relevant to the case. And these are the relevant facts because the court said they were the relevant facts, and this is how they're going to decide the case. So Rolex is a New York company. We don't really care where they start their watch company, but Rolex watches include the following components: the watch movement, watch case, the dials, the transparent crystals that cover the dial, the hands, the bezels, and the watch bracelet, sometimes called a watch band or strap. Additionally, Rolex has a legally protected interest in several trademarks, and these are what they include. They have a trademark for Rolex, Oyster, President, Crown Design, Date Just, GMT Master, Cosmograph, Sea Dweller, Milgauss, Oyster Perpetual, Yacht Master, Submariner, Rolex Daytona, Daytona, Explorer 2, Explorer, Air King, GMT Masters 2, and they're just going to call it Rolex for the purpose of this case. Again, if you are interested in getting a Rolex watch, go ahead and drop that in the chat. If you're watching this on the replay, go ahead and drop that in the comments. My boyfriend really likes Rolexes, so hopefully he doesn't hire Becker Time to go ahead and do his Rolex watch. But let me go back to sharing the screen. I don't know why I wasn't sharing it. Okay. Each new Rolex watch is covered by a 5-year manufacturer warranty, and Rolex will service the watch through centers in New York, Dallas, Los Angeles, Lititz, Pennsylvania, and they additionally have qualified Rolex jewelers that have operation centers throughout the United States. So you're not supposed to get your Rolex serviced by anyone that is not approved by Rolex. Where are we? Rolex sells genuine watch components to the ORJs, which are the official Rolex jewelers, allowing them to service the watches. Rolex additionally sells genuine Rolex parts to non-ORG jewelers. So they'll sell the parts to the non-approved jewelers, but those are the only ones that are supposed to be used to fix the watches. Once a watch has been altered with parts that are not genuine, Rolex will not guarantee the quality, the performance, or the function of the watch. Servicing a watch with non-genuine parts voids Rolex's warranty, which is why they are suing. They don't want people buying Rolex watches, and then let's say someone alters it, and then they try to sell it to someone else. It will decrease their value, and ultimately it could decrease Rolex's value, because if someone buys like a pre-owned watch and it's crappy and it doesn't work like a Rolex, then they're going to say, hey, Rolexes really aren't that good, even though they might not have bought their actual watch from Rolex itself. They could still think that Rolex made a bad product. All right. They won't service a Rolex with non-genuine parts unless Rolex is permitted to restore the watch to one made up of entirely genuine Rolex parts, which can probably get very expensive. There is a strong secondary market for the used Rolex watches that is, at least in part, as a result of Rolex's quality and longevity. And so this is what they're trying to prevent. They don't want people reselling Rolex watches and them thinking that Rolex did a bad job on it, and it really turns out that someone else altered the watch and they did not provide proof of that alteration. They basically don't want Becker Time's faulty work falling back on them. All right, so Becker Time is a Texas LLC, and Matthew and Carolyn Becker are the sole owners and officers of the company. Matthew Becker makes the major decisions at Becker Time, so that's why he's named individually in the lawsuit, because they're trying to pierce the corporate veil and hold him liable for the alterations that their company has made. So if they say, oh, our LLC doesn't have any money, we can't pay you, they can go after him personally and say, well, you pay us because you're also liable, and that can also bankrupt him personally, and it can also bankrupt the actual company, which will likely prevent them from doing it again. So that could be a good reason why they went ahead and named Matthew. in the lawsuit. I don't know why they didn't name Carolyn. Oh, because they said that Matthew makes the major decision, so he's at fault. They're saying he's at fault. Becker Time sells their watches on BeckerTime.com, Instagram Becker Time, Facebook Becker Time, eBay Becker Time to promote and sell their watches. Becker Time sells pre-owned watches that contains Rolex branded parts. So they sell watches that still have some of Rolex's branded parts. Watches sold by Becker Time are identified as genuine Rolex, but they contain both Rolex and non-Rolex parts. Remember earlier, we said that it's not under Rolex's warranty if they do not use genuine Rolex parts that are not approved by Rolex. So these are at issue watches. Rolex seeks an injunction to prevent future sales of these watches, as well as disgorgement of profits from past sales of the at issue watches. Leading up to filing this case, Rolex went ahead and purchased 2 watches for their investigation, and they're calling it Watch 1 and Watch 2 for the purpose of this opinion. And Becker Time added diamonds as hour markers, so it no longer has like the little stripes on there to show what time it is. They put diamonds there instead, which is crazy because Rolex actually makes watches like that. So I would think they're even infringing a little bit further than they're alleging in this actual lawsuit. All right, to refinish dials by drilling holes in the dials and placing aftermarket diamonds or other stones and settings in the hole. In the process of refurbishing dials, Becker Time strips the dial down to bare metal. Then, after the refurbishing process is complete, reapplies Rolex trademarks. So they're intentionally marking the watch as Rolex after they've already destroyed it. Okay, and Rolex does not perform or authorize any of these modifications. So they're basically doing it without permission. And Watch 1 listed, they're selling it for $4,299.98. And it is marked with a new MSRP. It's all factory win by Rolex, and they went ahead and added that mark onto the watch again when they used a different band. And then they also, oh, I missed it. Okay. The original price of a Rolex with the MSRP on it is $19,050. So way, way below. They're selling it for like $15,000 less, which is ridiculous and could cause Rolex to lose some of their credibility. And why is this watch so expensive when this one over here actually has diamonds on it? So I can see why they're mad. Okay. And then they went ahead and said the second watch is $3,000. I'm assuming they meant $3,399, not because they put the comma in like a weird place, which is weird because they're the court. And they also have the new MSRP on it, and that watch would normally sell for $17,800 through Rolex if it was real. So basically, substantially underpricing the watches of Rolex and again declining their value. And then I am going to hop back over to I Like Fish. She says, I thought LLC protects your personal assets. So your LLC can protect your personal assets, but if you are doing things under your LLC name, but it's beyond the scope of your LLC, then they can actually sue you personally, which is what they did here. They basically said that you guys were altering these watches and you should actually be held personally liable because you are the one that was intentionally doing this. So if the court finds that your LLC is not liable, we want the court to pierce your corporate veil and also hold you liable personally. So what Rolex did is they didn't just name the LLC in the lawsuit, they also are naming Mr. Matthew Becker in the lawsuit. And so if the court finds both of them guilty, then Matthew Becker will be on the hook of paying any money that Rolex wins in this case, which we'll get into whether they win any money in this case a little later on. So yes, your LLC is supposed to protect your personal assets, but if you are using it wrong, then it's not going to protect you. So you can't just go get an LLC and say, well, I'm a legitimate drug dealer because I have an LLC. the court's going to say, haha, no, you're still liable and you're going to jail, right? So you can't do illegal stuff under the screen of your LLC. So they basically say that the watches contain at least one Rolex trademark and aftermarket bezel that is not made or endorsed by Rolex. To some of the at-issue watches, including bezels with added diamonds. Again, Rolex did not do this to these particular watches, which technically makes it a bust-down Rollie that Rolex did not make. All right, and then Becker time sometimes applies aftermarket bands or straps not made or endorsed by Rolex on the at-issue watches that sometimes include a genuine Rolex clasp or buckle displaying Rolex's trademarks. Becker time provides an authenticity guarantee. So they're basically lying because they're going to get into it, but Rolex basically does not approve of these changes. So they cannot say this is authentic anymore because once they change things, it's no longer an authentic Rolex unless it was changed with authentic Rolex parts and done by a certified person by Rolex. All right, so Becker Time has held itself out to be a certified pre-owned watch dealer with a Rolex certified master watchmaker, but Rolex has never certified or endorsed any watchmakers. So again, another lie. Rolex has never certified Becker Time, its watchmakers, or any watches that Becker Time sells. So they're basically saying like, hey, bro, what are you talking about? You're not Rolex certified because one, that doesn't exist, and two, we definitely did not certify you. So Becker Time, I don't know what you got going on here. And then we get into the parts Becker Time adds is the at-issue watches do not bear any markings indicating Becker Time is the source. So the fact that they're not including that this is a Becker Time watch, they didn't add like a little stamp under the Rolex or somewhere else, they're basically trying to pass off this watch as a Rolex watch, which technically would be trademark infringement, which we're going to get into like the rules that go into play when we're talking about trademark infringement a little later on in this opinion. And so right now, if you're just now joining, we're just kind of going over the facts of the opinion that the court found relevant to finding whether these Becker Time people are actually infringing on Rolex's trademark. All right. So the quality of the majority of Becker Time's non-genuine Rolex replacement parts are inferior to the genuine Rolex parts. So they're basically saying the parts are crappy and you're ruining our watches. So stop it. Stop doing that. And so, for example, Becker Time sometimes prints the phrase superlative chronometer officially certified on a refurbished watch. Rolex uses the phrase to signify the watch's movement met a certain time accuracy standard when manufactured, but Becker Time does not investigate whether its watches meet those accuracy standards. Again, another lie, another way to show that trademark infringement is probably existing here. The result is that Becker Time mislabels watches to appear more valuable than they are. For instance, on one occasion, Becker Time mislabeled a Rolex date watch as a date just watch. This shows their authenticity certified statement is not fully accurate because they failed to verify the correct model of the watch. So we are partway through the factual, we got all the way through the facts relating to trademark infringement, and we're going to go into the facts relating to the digits confusion as far as the watch goes. So if you guys are here live, let me know what you think so far, just based on those facts that have been going on. Do you think that they are intentionally trying to pass off these Rolex watches, or do you think that these are actually, they should actually be considered Rolex watches? Because all they did, they only just changed it a little bit, right? Do you think that they should really be getting sued by Rolex, or do you think that they should comply with trademark laws and not change the Rolex watch? Do you think they should just make their own watches, or do you think it's okay that they're actually changing Rolex watches and then selling them as Rolex watches themselves. And so we have a matching birthdays for happiness. Hello and welcome to the live stream. How important is the operating agreement in the LLC or this case? So the operating agreement is super important. So for those of you who do not know what an operating agreement is, it is basically a contract between the owners of the LLC and the LLC, because the LLC is considered its own entity. So basically, if you're a single member LLC, you will just sign a piece of paper saying, this is what my LLC does. These are the rules that they follow, and we are a legitimate company. What the operating agreement will do for Mr. Becker here is if he has an operating agreement and he fully complied with everything under the operating agreement, it will kind of prove that he's not personally liable and that the LLC should only be liable. But if you start pulling out things where like Mr. Becker is just signing things under his own name instead of under the corporation name, or he's doing things even in accounting or something else that the LLC operating agreement does not allow for, that will give the court more ability to go ahead and pierce the corporate veil. So it's super important, if you guys have LLCs, to make sure you have your operating agreement and you're following it, and also that you keep a corporate record book. And anything that you sign on behalf of your LLC, you must indicate that you're signing it on behalf of your LLC. Don't just sign it as your regular name. You want to make sure you let them know, like, hey, this is personally for my, not personally, but this is strictly for my LLC. So do not put any liability on me. And so sometimes the operating agreement can protect you, but if you're doing something more like this, where you're intentionally infringing on someone's trademark, it's going to be a little bit hard for an operating agreement to protect you, because you can't go in there and say, or I guess you can, if you're sued for any infringement, then only the LLC is liable, and then it'll be up to the court to decide whether they're going to uphold that part of the operating agreement. But sometimes it doesn't even really make too much of a difference, because usually people will have more business in their LLC rather than in their personal bank account. So, but it does kind of stop you if they sue you for what's in your business bank account and your personal bank account, then you probably will stop doing the infringement because you won't have any money at all. So, yes. All right. So let's pop back over. Let's get big here, real big. All right, there we are. And now I'm little. All right, facts relating to the digits of confusion. So this is basically what the court is saying is considered confusion. The Rolex trademarks are arbitrary and fanciful. Arbitrary and fanciful trademarks are the strongest trademarks that you can have. Arbitrary is basically when you use a name or a word that is different from what you're actually describing. One of the examples would be Apple, using the word Apple to describe electronic products. When you think of an apple, you think of a fruit, which is completely unrelated to electronic products. So that would be an arbitrary trademark. And then fanciful will be something that you just completely made up. So Google was made up when they started Google. Kodak was made up when they started Kodak, but now you know it as the camera company, and you know Google as this internet, I don't even know what you would call it, phenomenon. So that's what arbitrary and fanciful trademarks are, the strongest trademarks that you can have when it comes to getting a trademark. Additionally, Rolex's trademarks are strong. The marks used by Rolex and Becker Time are identical, because Becker Time is just putting Rolex back on the Rolex watches. So yes, they're identical. They're not using Becker Time versus Rolex. Both Rolex and Becker Time sell watches. While Rolex deals exclusively in new watches, Becker Time does not sell new or even lightly used watches. Rolex is the exclusive distributor and warrantor of a new Rolex watch in the United States and is responsible for promoting, marketing, and selling new Rolex products in this country. Rolex sells its new watches exclusively through ORJs, which are the approved jewelers. And while Becker Time sells its watches exclusively online, there is not a brick and mortar store. Therefore, Becker Time customers cannot examine watches in person prior to purchasing them. So that's important. Becker Time sells these watches for a lower price point than fully Rolex watch would sell for. As we saw earlier, they are selling them for $3,000, $4,000 when a Rolex watch costs $17,000 to $20,000. All right, and then so we have Snuggles here. You giving me the eyes? Are you shocked that they're doing this? What are the eyes for? Okay, so I'm gonna pop over to the website. Is this gonna show? Okay, how do I unshare my screen and then share? Maybe I can do both. Okay, share screen. And so I'm just going over to the Becker Time website so you guys can see what their website looks like. All right, so this is their website. And as you can see, they have Becker Time. If you guys can see my mouse up here, small in the corner, beckertime.com. But when this little thing slides here, the first thing that pops up is Rolex. Huge inventory of Rolex watches. And then you go down here and it's a bunch of Rolexes. And mind you that this lawsuit has settled, and as a disposition, they did say that Becker Time is actually infringing on Rolex's watches. So I am surprised that they still have these watches super big and large all over the website, date judge, president, all the trademarks, literally all the trademarks that they're suing under are on the website, which is ridiculous, but they do have until February 19th to respond to Rolex in either getting rid of these watches. Rolex may give them a certain amount of time to get rid of the watches. They may tell them they have to stop immediately, which I'm assuming that was not the case here because they're still selling them, or they still have it on the website at least. I wonder if it'll let you buy it. Let's see. I guess they let you buy it. So yeah. So, I mean, I'm not going to put my credit card information into there, but they're still selling the Rolex watches despite this lawsuit. So that's fairly interesting. So let me pop back over to the lawsuit papers. So that was Becker Time's website. What do you guys think about that? I think that they include Rolex like super big to make it seem like they're actually affiliated with Rolex. Like their name is super small. So you will only find that by knowing that they are Becker Time and looking up their website. If you find them on eBay, especially. All right, we have DMV Nation. Welcome to the live stream. Wow, look at those prices for fakes. And so the thing is, this lawsuit is actually alleging that they're real Rolex watches that have, or no, they're saying that they're not saying they're real. But Becker Time is saying that they are real Rolex watches. They just changed it and then put the Rolex stamp back on it. But you can potentially be right that these are fake watches. Like they just use all their parts and put the Rolex stamp on it. There's no way to tell if they're genuine because they switched out so many parts even on the genuine watches. So that's interesting. I'm not too up on the watches, but they do look, the photography on the website does look a little old, so it makes it look a little fake. But if they are really fake, we will, or we won't find out, but I agree with you. They do look a little sus. All right, so I like fish. Are they pre-owned watches? That's what they're saying. They're saying they're pre-owned watches. But as DMV Nation pointed out, the pictures did make it look super fake. So it could be that they are completely fake, or it could be that they are Rolex watches that they just changed a little bit. But they said they changed them. Those ones didn't look too changed to me. So I don't know if they're just, well, earlier they said that they break down the actual metal and then re-put everything back on it. So maybe they're doing that to all the watches, but they're claiming that they're pre-owned so that they should be able to use the Rolex trademark because they're actually Rolex. And Rolex is saying, no, those are not our watches. So you need to stop. So that is what is interesting about that. Okay. Rolex spent hundreds of millions of dollars on advertising in the US. It's one of the best known watch brands. This is what they're saying. Becker Time intends to benefit from Rolex brand recognition. And I definitely agree with that because you saw how big Rolex was on the actual website. It's like they want you to think this is a approved Rolex seller, and they actually say they are certified Rolex billers. So I think they are using it. They are using their trademark. Okay, Becker Times benefits from the advertising and brand recognition of Rolex. Similarly, Becker Time intends to benefit from Rolex's brand recognition, but there is insufficient evidence to show intent to infringe on Rolex's trademarks. This is particularly true in light of the disclosures Becker Time made to its customers. So they're actually making disclosures of, oh no, this is not actually a Rolex watch. They make a few disclosures that this is not a Rolex watch, but you actually have to be on the website to realize that it's not a Rolex watch. So we're going to go through a little bit of the disclosures that they're given to kind of save their butt and say like, hey, no, we're not guaranteeing that this is genuine, but at the same time, they are. So we'll see how good they're able to explain this over. So let me pop this back up for you guys. There is some level of actual confusion exhibited by Becker Times customers regarding the authenticity of Becker Times watches. Again, we just saw the website, and Becker Time is very small on the website, and it says it's a Rolex watch. So they're saying Becker Times customers, but I would say they are still Rolex's customers that are getting cheap watches. Okay. Using Rolex certified watchmaker is confusing and suggests an affiliation or sponsorship. Some customers do not fully understand or fully read the description. So the liability falls on the person infringing rather than the customers, because under trademark law, the judges and the lawmakers assume that people do not pay attention when they're buying stuff. So you as a business owner should not be trying to trick them into believing that your product is something that it's not. So they're just thinking that we're out here willy-nilly just buying anything, which does sometimes happen. You don't really be paying attention and you end up with the wrong brand. Okay. Other customers have inquired as to the authenticity. As DMV Nation said, they look fake. Asking further specifications and stating they are confused on whether the watch is a fully genuine Rolex. This shows Becker Times disclosures did not fully alleviate confusion. Similarly, Becker Time has received complaints about the quality of the watches. Again, going back to what DMV Nation said, they look fake. And complaints that the watch was not actually composed of exclusively genuine Rolex parts. This shows some actual confusion. The product description on Becker Times' website and eBay listings indicate that the replacement parts are not genuine. So they did go ahead and put it on their website, but that does not mean that people are actually reading those disclosures, right? And which they're going to get into a little minute. It doesn't mean that if that person bought it from Becker Time and then they sold it to someone else, that second person is not getting the same disclosure as the first person that went ahead and bought the fake watch. Okay. And then I have a comment. Let's see. Where we go. DMV Nation says Frankenstein watches genuine parts but not matching numbers. I don't know what Frankenstein watches mean. I'm assuming that it's genuine parts but not matching numbers. Which they said sometimes they use the real parts and sometimes they don't use the real parts. And majority of the time is that they're not using the real parts. So, let's go back. Becker Time is not affiliated with Rolex. That the alterations will void Rolex's warranty. So they're telling people this, but Rolex is not having it still. They still think it's confusing for their customers. Most customers at minimum read the product description. The words genuine Rolex are more prominent than the disclosure. So they're basically putting genuine Rolex in big letters and then putting a little disclaimer saying, but they're not really. And Becker Times customers are not as sophisticated as Rolex customers. So they're basically saying people that go to the real Rolex website and go to Rolex's authorized dealers, they know what a real Rolex looks like, and they're willing to spend that $20,000 versus someone that's shopping on Becker time. They're potentially there to get a fake or a fraud because they know that it's going to be a lot cheaper than if they actually bought a real Rolex. So they're basically saying Becker times customers are not sophisticated, but they're not unsophisticated because they're still buying $3,000 watches. So they might know it may be fake, or they might suspect it may be fake. When asked by customers, Becker Time provides further product descriptions and reiterates that Rolex will no longer service the watches in question. But they are not telling this to the potential secondary buyers, or they're not responsible for telling the secondary buyer after someone buys it from Becker Time. Subsequent potential purchasers of Becker Time watches may not have the benefit of viewing Becker Time's product listings and disclaimers, which is what I was just talking about. Becker Time's altered watches are typically sold for less than Rolex new watches. As we've seen earlier, they're selling them for $3,000 and they're really supposed to be $17,000. So that is a big cut. That's what, $14,000? That's a lot. A big cut of Rolex's prices. All right, which puts purchasers on notice that they may not be fully Rolex watches. The disclosures fail to state that the watches are labeled as different models than the actual Rolex model than the watch is. Further, the disclosure misleads purchasers into thinking there is a comparable, genuine Rolex, that in fact, there is not always one. So this kind of goes to what DMV Nation said about the Frankenstein watches. They're saying it's this watch, but the serial number doesn't watch. They're also saying it's this type of watch, but it's not actually that type of watch. And so people might think, oh, Rolex made this new watch where they have a bunch of diamonds and a bunch of, let's say they put some rubies on it or something. Let's just say that. They have this watch and Rolex is like, we don't have that watch. So you're confusing our customers and they're coming into our stores and like, hey, where's the new Rolex watch with rubies on it? And they're like, what are you talking about? So this is what is potentially happening under this case. And so they want to make sure that Becker Time is not doing that to their customers because it's going to eventually fall back on Rolex and make them look bad. So they do not want any of that happening. Okay, so let's pop back over to this. And so now we're going into the defenses. When someone sues you, you basically have the right to assert your defenses. So say, okay, yes, I did this, but Rolex should not win because of this, this, and that. Okay, so now the court is going to point out the facts that will favor Becker Time for the infringement, that if the court finds that they did infringe, it will be their defense that why Rolex should not get money back or why they should not be stopped from selling the watches. All right, so popping back over, here we are. It's a defense called latches, which is going to explain it to you here. Latches basically is like you waited too long to file your lawsuit, and since you waited so long, it's unfair to the defendant to have to try to fight this lawsuit. If you would have filed it a little earlier, then they would not have gained so much damages. They wouldn't have to pay as much money because they would have stopped if you would have sued earlier on. So they're saying that Tracy Olivares worked at Rolex Watch in 2019. Olivares represented herself as being the Rolex corporate while inquiring about and placing a bid on a Becker Time watch in November 2019. The inquiry requested the serial number and the model number, as well as information about customizations. In responding to her email, Matthew Baker cited the description of the watch, which described the diamonds as aftermarket. Basically, that Rolex did not put these diamonds onto the watch. So she knew that it was not a genuine Rolex watch under the genuine Rolex watch definition that Rolex gives. Since at least 2006, the law firm Gibney Anthony Flattery has been Rolex's counsel. Their responsibilities include trademark enforcement throughout the United States at a minimum. Since 2010, GAF, which is the law firm, has been aware of Becker Time. This awareness includes knowledge of shipments to Becker Time of used Rolex watches. So they're saying that the law firm knew that Becker Time was receiving used Rolex watches in shipments. So not small amounts, shipments of it. From 2010 through 2013, Rolex and Becker Time communicated about various watches being imported into the United States and sent to Becker Time. When asked about the purpose of the shipment, Becker Time responded that the watches are being sent for repair, return, and repair under warranty. Rolex never sent a cease and desist letter. So they knew that Becker Time was accepting these watches and repairing them, and Rolex also knew that they were not an authorized jeweler of Rolex. So basically what they're saying is that they should have tried to stop them when that was happening. Lisa Sylvie is a paralegal with Gaff, the law firm. In an internal email in 2012, Sylvie stated Becker Time was a business she wondered about. In 2013, an email chain between Sylvie and the other Gaff employees revealed Rolex intercepted a watch that was supposed to go to Becker Time. In the email chain, the eBay ad that the Alta watch was sold through was discussed. The ad included a description of the modifications and customizations. Additionally, in 2013, an email between Gaff employees referred to Becker Time's watch as junk. So they knew it existed and they knew that it was a bad watch. Rolex does not refer to their own modified watches as junk. In another email exchange with a partner at Gaff, Sylvie stated, Becker Time will not be getting this one. Basically saying that, oh, we know that they're taking our watches and changing them, but not this one. The majority of Becker Time's business is built around the sale of the at-issue watches, but Becker Time has not invested in a large amount of Rolex inventory. I personally would disagree with the fact that they have not invested in a lot of Rolex inventory, because when we just went on their website, let's go back on their website. Did I close the window? No, I didn't. All right, so let me go back to their website and we're going to look at their inventory, assuming that all of these watches are available on their website, because they still have them up here. So that was the one we clicked on. Okay, go back. Okay, here we go. This is their homepage. It pops up big Rolex. Like, they want people to know that they have Rolex. And then it says lifetime trade up guarantee, but they're not really specifying that they will need to trade it back to Becker Time. People might think that they can trade it back to Rolex. They're offering discounts up here. All of these are Rolexes. Rolex watch, featured products, Rolex parts and accessory, other watch brands are four steps down. So for you to say that you're not trying to, oh, what was my point? I forgot. So for them to say like they were not intentionally trying to do that, it doesn't really make all that much sense. So let's pop this back up. That they didn't have any inventory, when we can look on their website and Rolex is at the top and all of these other watch brands are listed as other watch brands, and they're 4 steps down from the list of their watches. So they're also arguing that they have fair use of the trademark, basically that they can use the trademark because I think they're going to say it was altered. Yep, that's where it's highlighted. So that they should not be liable for trademark infringement. So Becker Time is not using the Rolex trademarks to identify Rolex products. Instead, as discussed above, Becker Time uses Rolex trademarks to identify its own altered watches. That's not what fair use is. Further, Becker Time's statement that they employ a Rolex certified watchmaker, there is no such designation, so they made that up, suggests affiliation or endorsement by Rolex. So they made that up. The next thing they're arguing is waiver. The court says there's no evidence that Rolex intended to relinquish its trademark rights to Becker Time. They did not sit there and say, oh yeah, go ahead and use our trademark. They didn't do it. And then the next one is the first sale doctrine. The goods sold by Baker Time are materially different than the original Rolex watches. Baker Time does more than stock display and resell Rolex watches. So let's get into the actual law. For those of you that are watching live, what do you guys think so far? We've seen their website. We've seen what the watches look like. We see that they are advertising Rolex watches, but they're trying to say that it's not actually a Rolex watch. And to me, that doesn't make sense. I feel like you're basically admitting to trademark infringement at that point. If you're watching this on the replay, go ahead and comment below what you think about all the facts that the court has cited so far. And so we are halfway through this whole shindig here. So let's talk about the law that relates to trademark infringement, because I don't see any comments popping up here. So lawsuits for infringement of a registered trademark are governed by the Lanham Act, basically just a statute that covers trademark law. And then to recover on a claim of trademark infringement, a plaintiff must show that the mark is legally protectable and must then establish infringement by showing a likelihood of confusion. Do you guys think that there is a likelihood of confusion so far? To determine if a mark is legally protectable, courts look to see if the mark is registered and incontestable. A certificate of registration of a mark upon a principal registration shall be prima facie evidence of the validity of the registered trademark. This is basically saying, like, if they have a registered trademark and they've been using it for 5 years, then it will be established that it is an incontestable right to the name. So we're going to skip all of that because they use a lot of words just to explain that. But yes, they have a valid trademark registration. Rolex has been in existence for years. They even cite Rolex's own cases from like 1989 to support their findings in this case. So this Rolex has been around, and we know that Rolex is their trademark. So no need to fight that. To prevail on the claim of trademark infringement, Rolex must show that Baker Time's use of the mark created likelihood of confusion in the minds of potential customers. Like I said, do you guys think this is confusing so far? We have Alpha. Hello and welcome. For those of you watching who do not know, this is my boyfriend. And he says, yeah, they're copying and have such a large inventory. I agree with you there. Are you still going to buy a bust down Rolex? Because you might be buying infringing Rolexes. Well, I don't think you want to bust down, but would you buy a bust down Rolex, or do you think that's not a good idea, especially after this case? Trademark infringement occurs only when, oh, did I roll out of this? Okay, yeah. Trademark infringement occurs only when the use sought to be enjoined is likely to confuse purchasers with respect to such things as product source, its endorsement by plaintiff, and its connection with the plaintiff. Likelihood of confusion is synonymous with the probability of confusion, which is more than a mere possibility of confusion. And again, this is just giving us the laws that apply to finding trademark infringement. All right, and Alpha is not going to get a bust down Rolex. I appreciate that, because then I would have to talk to you about how you're trademark infringing. All right, in determining whether a likelihood of confusion exists, courts consider the following non-exhaustive list of factors: the type of allegedly infringed, or the type of mark allegedly infringed, which would be like if it's descriptive, arbitrary, fanciful, suggestive, or generic. And as it has already been established, Rolex is an arbitrary and fanciful trademark. Similarity between the two marks, the similarity of the products and services. So the similarity between the two marks is that they're both used in Rolex, so they already won on that. The similarity of the products and services, they are selling watches, and Rolex sells watches, so, and they also repair watches. So Rolex wins on that. Identity of the retail outlets and purchasers. The identity of advertising and media use could be different. The defendant's intent, did they really intend to infringe on Rolex's rights? What do you guys think? and evidence of actual confusion, which they've kind of pointed out some of the customers already being confused. Courts also consider the degree of care exercised by potential buyers. So someone spending $20,000 is probably going to look twice before they actually buy that product. But somebody spending $5 is probably not going to be like, okay, well, this one is 15 cents more, so it must not be real, or it must be real because it's 15 cents more. Versus in this case where Becker Time is charging $3,000 and Rolex charges $20,000, then you might be like, is this really a Rolex watch, or what's going on here, right? And then we have Alpha saying plain from an authorized dealer is the Rolex that he will be getting. I can appreciate that. We don't want to talk about trademark infringement when you're wearing your Rolex watch. No single factor is dispositive, and a finding of likelihood of confusion does not require a positive finding on the majority of the digits of confusion. Basically, what this is saying is that if they win on one thing, it does not mean they win on everything. Or if they win on a lot of things, does not necessarily mean that they win infringement all the way. You basically have to balance the factors, is what the court refers to it as. Oh, I'm not sharing my screen. There we go. Although not necessary to finding a likelihood of confusion, a defendant's intent to confuse may alone be sufficient to justify an interference with the likelihood of confusion. Selling watches of a similar or identical design to the genuine Rolex products and using unauthorized copies of Rolex's trademarks demonstrates an intent to derive benefit from the reputation, goodwill, and market created by Rolex, which I agree with, because they were literally taking off Rolex's trademark that's on the watch when you get it, sanding down the metal, building the metal back up, and then putting Rolex's trademark back on the watch. Like, if that's not intentional deception, I don't know what is. But they tried to fight the case. All right. A plaintiff hoping to establish a likelihood of confusion exists is an infringement action may utilize the following methods of proof: survey evidence, evidence of actual confusion, or arguments based on clear inferences arising from the comparison of the conflicting marks and the context of their use. So basically to show that people were actually confused with what Becker Time was doing, then you can use these different things. Actual confusion need not be proven, but if customers have confused the junior mark for the senior mark, then this is the best evidence of likelihood of confusion. To show actual confusion, a plaintiff may rely on I cannot say that word today. I know I can't. Anecdotal instances of consumer confusion or customer surveys. So that's just saying, like, basically how they can establish the actual customer confusion. Even if products are not identical, there is a little likelihood of confusion that they are expensive and unlikely to be purchased impulsively. So if something is expensive, then it is a little less likely that they will just spend the money and not really consider whether it is a genuine product. Okay, confusion is also less likely with sophisticated customers. Rolex purchasers are very sophisticated, but sophistication is not dispositive. So basically, just because they know and they're very familiar with the watches does not mean that it's not infringement. Sophistication relevance is limited here because the watches are mislabeled, something even a sophisticated consumer is unlikely to know without substantial independent research or a third-party evaluation. So the court is basically voiding the sophistication element of proving that they're not actually infringing. Post-sale or post-purchase confusion is indicative of a violation of the trademark laws as direct purchaser confusion. As in cases involving Lanham Act, the presence of likelihood of confusion disposes of the issue of infringement. So basically, infringement and confusing customers are the same thing. The elements of trademark infringement and false designation are identical. They're basically saying that trademark infringement, false designation, likelihood of confusion, and all of those things support an action for trademark infringement. So we're not going to read all of them repeating it because they're basically saying if you're liable for a likelihood of confusion, that you have infringed on trademark and provided false designation of origin. So there we have that. In the case of counterfeit marks, likelihood of confusion is clear. A trademark counterfeiting claim requires likelihood of confusion and proof that the defendant is using a counterfeit mark. The counterfeit mark is a spurious mark which is identical with or substantially indistinguishable from the registered mark. Bearing the original mark does not immunize items from being counterfeit. So in this case, they went ahead and tore down the Rolex watch and then turned around and re-put the Rolex name back on it, which will make it a counterfeit. And even if they don't take off the Rolex watch name or the Rolex off of the watch, then it could still be considered counterfeit under these laws. When a defendant uses plaintiff's exact mark, which they did, they used Rolex, courts within the circuit have determined that a thorough analysis of the digits of confusion is unnecessary. So they're basically saying we're not considering any of those 8 factors that we talked about earlier because they are actually using Rolex's trademark. So they say that they can do that, but they said they're not going to do that. And they actually do go ahead and balance those factors that we went over earlier. So let me turn this little dude off, and we're going to turn this little dude on, and we're going to pop back over to the comment section. No new comments. So back into the balancing of the factors. Let me know if you guys think that they have infringed already. I know I have given my biased opinion all throughout this video as being a trademark lawyer, but let me know what you think. Do you think that they can still win? Do you think that they are actually violating Rolex's trademark rights? Okay, so Becker Time used Rolex marks on goods covered by Rolex registrations, and the use was unauthorized by Rolex. Becker Time's use of Rolex trademarks on the watches altered with non-Rolex parts is trademark counterfeiting because Becker Time modified date watches to resemble more expensive date-just watches. Becker Time added superlative chronometer officially certified despite the fact that the watch was not certified by Rolex. Becker Time refinished and replaced diamonds on the genuine Rolex dials. Rolex did not perform or authorize the modifications, and its warranty was voided by Becker Time's activity. Becker Time, not Rolex, stood behind the watches, but the trademark suggested otherwise. Just like we just saw on the website, they said you can trade it in, money back guaranteed, no matter what. But they didn't specify that, oh, you can only trade it back into Becker Time if you don't like it. Okay. All right. Becker Time distributed refurbished watches without any markings or disclosure that would reach secondary purchasers. So basically, they told the disclosures to the people that were directly buying for Becker Time, but there was no way for, like, let's say I bought a watch and I wanted to sell it to my friend. There was no way for anyone to see that they were selling, that it's no longer a Rolex watch when you're selling it to the third person, the third party. Or they're calling it secondary purchasers. Further, the court finds the digits of confusion point towards likelihood of confusion. Oh, I lost my train of reading. Oh, likelihood of confusion and therefore infringement. The parties stipulate that both digit 1 and 2 favor a finding of infringement. The facts show that digit 3 is neutral. The digit 4 and 5 weigh in favor of Becker Time, and 6 and 7 weigh in favor of Rolex. Despite Becker Time's disclosure of certain modifications, Becker Time failed to disclose that the labeling added to the watch was incorrect. So the court finds that they are actually liable for the trademark infringement. And so we have a comment here by Alpha. Says, how much money has Becker Time made from selling fakes? They did not tell this, and I did not download the paperwork that would have let us know how much they sold. And it's potentially that they did not even tell them how much they sold, and they would have been required to tell them that if the court does not find the next things that we're going over. So I don't know how much they've made, but they have been in business for 25 or 24 years. So that is a long time. So I'm assuming that it was a profitable business because they have been selling for 24 years, and they're selling on their own website. They're selling on eBay. They're selling on Instagram and some other websites that we listed earlier. So I'm assuming that they made a lot of money over 24 years, honestly. All right. Lastly, despite Becker Time's disclosure of certain modifications, Becker Time failed to disclose the labeling added to the watch was incorrect. And I already read that, but that's okay. Similarly, Becker Time's placements of original Rolex clasp on non-genuine bracelet increased the likelihood of confusion as to the genuineness of the watch. So they basically put it on Rolex's clasp to make people think that it is an actual real Rolex watch. Activity constituted counterfeiting under the statute. Although Becker Time argues that most watches were sold in response to customer requests, so now they're trying to blame it on their customers, saying they asked us to do this. So there should be no infringement, which is ridiculous. You can't just go around changing stuff and say, oh, well, my customer asked me to do it. You're the business and you're the owner. So you have to make those decisions. And you were doing it anyway. So you can't blame the customers. They knew you were going to supply fake things. It's like drug dealers saying I shouldn't be liable because they wanted the drugs anyway. So it's not my fault, which I'm sure people think that, but okay. Although Becker Time argues the most watches were sold in response to the customer request, once the product is injected into commerce, there is no bar to confusion, mistake, or deception occurring at some future point. Therefore, the court finds that Becker Time infringed on Rolex's trademark protection by counterfeiting Rolex watches. So not only is the court calling it fake, they're also saying that they counterfeited it. So they're not even calling them fake watches anymore. They're using the big legal terms on them, saying they have counterfeited. All right. So basically, Becker Time loses. So the next question is whether they're going to have to pay Rolex and whether they're going to have to stop selling the Rolex watches. And whether they're going to have to pay Rolex is going to be determined by the actual defenses, if they were able to prevail on the defenses of the case. So we're going to jump into that right now. Do what thou wilt. Hello there. Welcome to the stream. We are almost at the end. So if you didn't watch earlier, you can go ahead and pop back to the beginning once we go ahead and finish this live. So we're going to go ahead and go through the defenses that Becker Time alleged. Remember, they did latches, which meant like that they waited too long to sue. So let's look at it. Latches comprises of three elements: delay in asserting one's trademark rights, lack of excuse for the delay, undue prejudice to the alleged infringer, which would be Becker Time, caused by the delay. The period for latches begins when the plaintiff knew or should have known of the infringement. We're going to get into that. An agent's knowledge is imputed. So basically, if someone works for you and they see that something is going wrong, if they're considered an agent of your company, their knowledge of any of the infringement goes on to the company as well, because they were responsible for telling their boss that someone is infringing on their trademark, is basically what they're saying. And in this case, they are saying the fact that the, the law firm knew of this infringement, then they should have told Rolex and they should have sent the cease and desist letter, or they should have sued them years ago. All right. Imputed to the corporation where the agent is acting within the scope of his authority, which the law firm has the authority to assert trademark rights, and where knowledge relates to the matter within the scope of the authority. At minimum, Rolex agent through GAF should have known about Becker Time in 2010, 10 10 years prior to filing the lawsuit, and no later than 2013, when Sylvie wrote that Becker Time watches were junk. So they knew about the watches, they should have reported it. Rolex offers no valid justification for this delay. A defendant who intentionally infringes a trademark with bad faith intent to capitalize on a mark holder's goodwill lacks clean hands. So basically, what Rolex is trying to argue is that Becker Time actually intentionally copied Rolex and tried to present the watches as a Rolex, so they cannot use the defense that Rolex took too long to notify them of the infringement that they were doing. Rolex didn't have to notify them because Becker Time was basically intentionally doing this to them, so they shouldn't be held liable. So let's pop back over here. The plaintiff's burden, therefore, is heavy to foreclose the laches and equiance defenses. The plaintiff must offer something more than a mere objective evidence to demonstrate that the defendant employed the allegedly infringing mark with the wrongful intent of capitalizing on its goodwill. It's inherent in the resale of luxury goods that sellers wish to benefit from the reputation and goodwill of the brand name. This is not sufficient to show unclean hands necessary to prevent a party from benefiting from laches. They're basically saying that just because Becker Time wanted to benefit from Rolex's name, Rolex needs to show more than the fact that they were luxury. Becker Time knew that they were benefit, or they intentionally benefited. They needed some type of animosity against Rolex in so many words, is what the court is saying. Ultimately, Rolex failed to show subjective and knowing bad faith necessary to foreclose equitable defenses. So Becker Time is not going over there and putting out Rolex ads. They're still including Becker Time on there. They're not going to Rolex's stores and trying to steal their customers and things like that. Laches is a good defense if plaintiff's long failure to exercise legal rights has caused defendant to rely on its detriment to building up a valuable business, a 24-year-old business, around the trademark. Measuring prejudice entails balancing equities. Becker Time likely would not have shifted its business model to be reliant on the sale of altered Rolex watches if Rolex had brought the suit promptly. And as we saw on their website, they had a bunch of Rolex watches. So they did rely on the fact that Rolex was not suing them and thinking that they were allowed to sell them. Becker Time relied on Rolex cooperation in building this valuable business, and Rolex assisted Becker Time with the importation of watches for repair or return. Therefore, after balancing the equities, the court concludes Rolex may not disgorge Becker Time of profits, even though Becker Time is enjoyed from further infringing activities. So the court is basically finding that Becker Time won on their defense of laches, so that Rolex cannot take away their money, but that Becker Time does have to stop selling the watches. So they're not going to have to pay Rolex, but they do have to stop selling the watches. So technically, they're going to lose money on that inventory that we just saw on the website. All right. And then we have waiver. To find waiver, the defendants must prove that the right existed at the time of waiver. Plaintiff had constructive or actual knowledge in question. Plaintiff intended to relinquish the right. Becker Time has failed to provide evidence Rolex intended to relinquish their rights to their Rolex trademark. Therefore, Becker Time does not win on their defense of waiver. They also argue fair use, which nominative fair use permits one to use another marks truthfully to identify another's goods or services in order to describe or compare products to the market holder or to the mark holder products. They didn't do that. They literally said this is a Rolex watch, so that doesn't work. For an affirmative defense of nominative fair use to apply, the use cannot be one that creates likelihood of confusion. Again, they created likelihood of confusion, as was decided by the court earlier on, because they were using Rolex's name on altered Rolex's watch, which are not considered real Rolexes. Becker Time is not using Rolex marks to truthfully identify Rolex watch, but instead their own modified watch. Therefore, Becker Time is not protected by fair use. So they're not fairly using the Rolex trademark, because the only way they will be able to do that is if they were saying, hey, buy our watch. It is comparable to Rolex. But they weren't doing that. So it did not apply for Becker Time. So they lost on that defense as well. But good try. First sale doctrine. The first sale doctrine holds that the trademark protection of the Lanham Act are exhausted after the trademark owner's first authorized sale of the product. The theory behind the resale rule is this: when a purchaser does no more than stock display and resale of producer's product, consumers are not confused as to the origin of the goods because the origins has not changed. The first sale doctrine does not protect those who sell trademark goods that are materially different from those sold by the trademark owner. In this case, Becker Time took the Rolex watches, changed it, shaved the metal down, changed the bands, put diamonds on it, basically reducing the value of the Rolex watch indicated by the price that they were selling it at, which was $3,000. And then they turned around and, or it was $3,000, and the actual price of a Rolex was $17,000 in comparison. So yeah, you guys materially altered the actual watch. So you cannot apply the first sale doctrine. The watches sold by Becker Time are materially different than those sold by Rolex. Therefore, Becker Time is not entitled to protection under the first sale doctrine. So they would have been entitled to protection under the first sale doctrine if they just bought a Rolex watch and then they sold the Rolex watch. But instead, they bought the Rolex watch, they changed the Rolex watch, put Rolex back on the watch, and then tried to sell it as their own watch. And they did not put Becker Time on the watch. All right, so basically the court ruled and found that Becker Time has infringed on Rolex's trademark and that they have to stop selling the Rolex watches, which I might go ahead and go get the documents of their response and how long they have to stop selling the Rolex watches, because those Rolex watches are still on their website, as we saw earlier, and there's a bunch of them on the website. And then they basically have until Rolex has until February 9th of 2022, which was a week and a half ago, to let the court know how they want Becker Time to stop using their trademark. And then Becker Time has until February 19th to respond to those requests. So that's in 2 days. So basically, Rolex is going to tell them, hey, you have to stop selling our watches by such and such date. And if you don't stop selling them, give me the money, or you have to destroy them or return them to us, or however they want to get rid of the watches, they are going to put that into the documentation. So ultimately, if you chose that, at the beginning of the live stream, I asked whether you think that this was trademark infringement. If you thought that it was not trademark infringement, then you technically lost the case. But Becker Time did not lose all the way, because they're not going to have to pay back all that money that they've collected for the past 24 years selling Rolex watches. So they lost because they were found to be trademark infringers, but they do not have to pay any money. They just have to stop selling the trade or stop selling the watches under the Rolex name. It'll be interesting to see when they actually stop, and if they're going to be sued again, because they're not going to stop, because it seems like that was their most profitable part of their business, because they listed Rolex watches as soon as you got on the website, and then other watches are literally listed under other watches, but they're supposedly supposed to sell other luxury watches. So you will wonder why they emphasize so much on Rolex, especially during this lawsuit. I'm surprised they didn't get a preliminary injunctive relief so that they couldn't be selling it during the lawsuit. But I guess it worked out for them. They don't have to pay Rolex, which is a huge company that makes a bunch of money because people pay $20,000 for their watches. So lucky for Becker Times, they didn't have to pay them back. If you are in business, do not go around altering products and selling them off as your own while still bearing the trademark of like Nike shoes or Rolex watches. If you guys see any cases that you would like for me to cover in the future, please go ahead and comment on any video that you see. Thank you for watching the live stream. And remember that this was not considered legal advice, just legal commentary. And I am not trying to tell you how to live your life as far as trademark infringement goes. I hope to see you on the next live stream. Have a good night.